Q&A interactive discussion. And so I asked if you have any questions, please type them in the chat, or once we hit the Q&A session, just use the raise hand feature and we can call on folks in order. And so to kick us off, we're delighted to have y'all join us today for the USIBC webinar on intellectual property enforcement in the digital space. Intellectual property, especially these days, is absolutely essential to innovation, creativity, progress. And in today's world, digital platforms shape our lives every single day. And so safeguarding intellectual property rights becomes even more important. And so we're actually joined today by USIBC Intellectual Property Rights Knowledge Partners, Shardul Amarchand Mangaldas, to explore the nuances, the challenges, and honestly, the opportunities in enforcing IPR within the digital landscape. And so I'm actually going to go ahead and turn it over to our two experts, JV Abhay and Apurva Murali. Apurva is a partner at SAM, and she has an expertise in various aspects of intellectual property law with a particular focus on patents. And she specializes in navigating complex litigation, particularly in media and IP-related disputes. JV is also a partner at SAM, and he actually heads up the IP litigation practice. So he handles complex IP disputes across a whole bunch of various sectors and has been a leader in the field for almost 2 decades. So they are truly the two experts in this topic. I'll also mention that if anybody would like to connect with them offline about anything, just let me know and I'll be happy to make those introductions. So JV and Apurva, over to you.
Thanks, Ali. And good evening, good morning to everyone. And today, what we are trying to do is provide a broad perspective on how intellectual property is enforced in the digital space. There have been a lot of recent developments with such enforcement, especially with courts in India taking a very dynamic view of certain situations. And especially there has been a lot of development with courts granting dynamic injunctions. With technology and the digital space expanding, there have been a lot of issues which right holders have faced while enforcing their intellectual property, whether it be the issues in the metaverse or whether it be on account of AI. So intellectual property enforcement has actually had to develop in a manner that it had to catch up with the growing technology. The traditional means of enforcing intellectual property has undergone a huge change. There are many hurdles while one wants to enforce intellectual property in the digital space. Of course, with the emergence of e-commerce and streaming services and social media, there are new challenges which have come up. The amount of IP infringement has increased substantially. There are several factors, new factors, which come into play while enforcing IP rights in a digital space, which were previously unknown in the traditional IP enforcement scenario. Now, India has actually kept up pretty well and has adapted nicely with these measures of IP enforcement and for dealing with these emerging threats of IP infringement online. Some of the examples of these threats to IP rights include spoofing, which is a very broad term, which includes typo squatting, farming, and phishing, for example. All these are subsets of spoofing. This is a very good example of how the digital media has posed a larger threat to enforcement of intellectual property. Then there are, of course, issues of territorial limitations, anonymity, and change of URLs. Uh, the courts, especially the Delhi High Court and the Bombay High Court, have dealt with these issues and come up with their own ways to tackle with or new solutions to tackle with these issues, which have arisen primarily because of growth of technology. Uh, One of the most effective remedies to counter such illegal activities on the internet or in the digital space is to approach a court by way of a suit and to secure an order of injunction. These orders of injunctions have been prevalent from times immemorial. But there have been situations where the courts have kind of changed the kind of injunction orders which are passed by them in particular facts of each case, especially when it pertains to an infringement on the digital space. Um, so these injunctions can be sought against not only the infringers, it can be sought against the domain name registrars and the telecom operators. This is something which has evolved over time, and one of the most important developments which has happened in the recent past and starting from 2021 is the setting up of IP-specific benches, especially by the Delhi High Court and the Madras High Court. Calcutta is still contemplating setting up one. There are certain rules which have been floated around. Bombay does not have an IP-specific bench. These IP-specific benches have been set up primarily to deal with the growing inflow of IP infringement cases, especially on the digital space. And these were set up because there were certain concerns which were emanating from right holders, that certain kinds of infringements are going unchecked and certain kinds of infringements are taking a very long time to be dealt with by courts. So this is a very positive move which has happened. The Delhi High Court set up the IP benches in 2021, and the Madras High Court has followed suit in April 2023. Obviously, there have been certain rules which have been prescribed for these IP benches to take up IP issues and to deal with them. The Delhi High Court was the first of its kind to set up an IP bench. The rules which it adopted have now also been adopted by the Madras High Court. More or less the same rules have been adopted with slight change because the Madras High Court is a charter court. So the other issue that that we need to concentrate on and which we will be dealing with today is on the injunctions. As I mentioned, that getting an injunction is perhaps the best relief that one can get against infringers and to deal with infringements on the digital space and otherwise. These injunctions can be of three kinds. One is an ex parte injunction, the other is an interim injunction, the third is a permanent injunction. An ex parte injunction is an injunction which is granted by the court without the presence of the defendant. Of course, this ex parte injunction will have to be confirmed at a later stage. Interim injunction is an injunction which includes an ex parte injunction which has been confirmed or an injunction which has been granted post arguments made by both parties once the court has heard both the parties. The permanent injunction, of course, is the final relief in any suit. Now, for an injunction to be granted, a plaintiff has to show three things. One is prima facie case. Second is the balance of convenience, and third is irreparable harm or injury. If the plaintiff is able to show these three tenets, then the court generally grants an injunction. Now, John Doe injunctions are something which have been prevalent in India since at least 2002. The Taj Television versus Rajan Mandal was the first of its case in 2002, where the court issued a John Doe order or John Doe injunction and restrained unlicensed cable operators from broadcasting the 2002 FIFA World Cup. The transmissions by these defendants were happening illegally, and the plaintiff was able to get an order of injunction against these defendants. So this was the first of its kind. These John Doe orders generally in India are also termed as Ashok Kumar orders. Now, John Doe orders or injunctions are ex parte in nature. Uh, in a suit where a John Doe injunction is sought for, not all defendants are identified. It may be a case where a few of the defendants are identified and the others are termed as John Does or Ashok Kumars in India. These are issued in matters wherein the defendant is unknown or unidentified. It may be a case where all defendants are unknown, but generally what happens when a suit is filed is that the plaintiff will identify one or two defendants, and the others are termed as Ashok Kumars or John Does. Initially, in order to curb misappropriation of IP, courts used to grant injunction orders blocking the infringing content with respect to specific URLs. But however, with time, what has happened is that blocking of infringing URLs were effective only at the very outset. Now, what has happened is with the advancement of the digital realm, moving the infringing content has become very easy. So what happens is if one URL is blocked, then the content is moved to a different URL. And this can be done in a matter of seconds. So what has happened is that this has led the courts to grant stricter orders wherein the entire website hosting the infringing URL was blocked or taken down. We have actually judgments on both issues. Some of the courts have held that the entire website should not be blocked. On the other hand, a few of the judgments of the Delhi High Court have held that the entire website ought to be blocked. So Dabur India versus Ashok Kumar and others is a judgment of the Delhi High Court. This is a judgment of Justice Pratibha M. Singh. In this case, the defendants were using Dabur as a part of their URLs. The ISPs and MeitY were also made a party in the suit. So what the defendants were doing was that they were using the trademark Dabur, and they were also portraying themselves to be associated with the plaintiff. The names and identities of the individuals were masked by the domain name registrars on account of the privacy. So post the GDPR rules, this was something which was happening very regularly. So the court took note of this issue and it directed the registrar of domain names to provide details of the infringers, even though their details were masked on account of privacy. The court directed that all details of the defendants be provided to the court by the registrar. And of course, an order of injunction was granted against all. So the next judgment that I would like to discuss is Gujarat Cooperative Milk Marketing Federation. Um, this is also a judgment of the Delhi High Court, and this is an order dated August 28, 2020. This judgment actually has a great precedence value in it, because what had happened was that a lot of the infringers were using Amul as part of their domain names. Now, the court granted an ex parte ad interim injunction in favor of the plaintiff and directed several of the domain name registrars to block or suspend the fraudulent websites which contained the trademark Amul. The court also directed the registrars that they should not offer for sale domain names which included the trademark Amul. Now this is significant because this kind of indicated that the registrars should indulge in active policing, which generally is not something which is expected of an intermediary. Um, Now, the order has gained attraction, of course, and it was followed in several subsequent judgments. But there was a judgment subsequent, which we will also be dealing with, which does not agree with the view which has been taken in this judgment. Uh, Post this, what has happened is, given that this issue of infringement on the digital space uh, has kind of not been restricted to territorial limits, the courts have come up with dynamic injunctions. Now, the beginning of the dynamic injunctions was since or what the court calls it as on account of Hydra-headed monsters coming up. That means that once a website or a URL was blocked, it was mirrored and several other such mirror websites used to come up. Now the court had to deal with such an issue. Now the initial trend was such that the courts used to examine whether the primary content on a website is pirated or unlawful and used to pass an order blocking the entire website. For a few years, of course, as I said, blocking of an entire website was an effective remedy. But of course, something had to be done where infringing content used to be mirrored on new websites or new domain names. Now, dynamic injunctions arise when a continuing injunction is issued, the specific targets of which are not mentioned in the primary order, but rather an emphasis is laid on the impugned subject matter and protected right, thereby including it in its ambit any potential infringement. So a dynamic injunction also includes in its ambit any potential infringements and not just infringements which are happening on the date on which the order is passed. They are, as I said, they are usually invoked when the infringing content arises with a new username or URL or mirror websites are created, which forward to another website holding the infringing material with or without masking. So dynamic injunction was something which was considered by the Bombay High Court in Eros International. This is a 2016 judgment of the court. This pertained to hosting of illicit links by unauthorized websites of the popular Bollywood movies, Udta Punjab, and certain other movies. The Bombay High Court refused to pass an order of injunction blocking the entire website. Now, the logic to that was that there may be cases where uh, innocent users may also be made a subject matter of such injunctions being passed. So what the court came up with was it came up with a three-pronged test. It considered the three-pronged test which the plaintiff had suggested, that the plaintiffs had conducted certain investigations through a private investigator, filed an affidavit confirming that the websites were actually mirror websites or infringing websites. The plaintiff itself had also done an investigation by itself and cross-checked that these were indeed mirror websites and filed all these on an affidavit. So the court considered all these factors and passed an order of injunction. The court emphasized that an order for taking down the entire website should not ideally be granted. And unless, of course, the entire website contains infringing material. The court actually preferred the old method of blocking specific URLs, which the plaintiff provided to it and which were seen as infringing, and accentuated on the need of appointment of a grievance officer to route all such complaints relating to infringement. Now, after this, we also had the UTV Software Communications Limited versus 1337. This is a judgment of the Delhi High Court. This is Manmohan's judgment. This is actually the case where the court went in detail and dealt with the issue of mirror websites coming up and dynamic injunctions being passed against such mirror websites. So how the court terms these mirror websites is as Hydra-headed monsters or Hydra-headed rogue websites. So the court came up with a definition of what rogue websites were. Now, this was actually a significant development from the decision in Eros International, because Eros International of the judgment of the Bombay High Court, which I just discussed, held that the entire website ought not to be blocked. In this case, an injunction was sought against websites, including torrent websites, which were illegally providing original content, in this case, which were films. So the court considered the principle of proportionality between the plaintiff's IP and defendant's right to trade and freedom of expression. Contrary to Eros, as I said, the Delhi High Court noted that blocking of entire websites may be contrary to open internet, but sometimes is a requirement to curb illegalities. And as I said, the concept of rogue websites was introduced. The defendants' websites were termed to be as rogue websites, and ISPs were directed to block access to defendants' websites. Now, as per the definition of the court, what were these rogue websites? The term rogue websites was defined by the court, and it held that the factors to be considered when determining whether a website is a rogue website or not are the following. Whether the website primarily contains illegal/infringing content, whether the contact details of the registrant are masked, whether the website refuses to accept takedown requests, whether identification of specific URLs would be burdensome to plaintiff, whether the website facilitates or promotes other infringers by providing related details, whether the website has adequate volume of traffic. So these were the tenets which were to be considered before determining whether a website is a rogue website or not. Pursuant to this order, what has happened is that the court has given liberty to the plaintiff to approach the joint registrar of the court, because the court felt the need to lessen the burden on it, that the plaintiff ought not to approach the court every time to implead these mirror websites. So what it did was it granted the liberty to the plaintiff to approach the joint registrar, who's an administrative officer of the court, and to file an impleadment application against every new mirror website which came up, and by filing an affidavit showing how these mirror websites were infringing the plaintiff's rights. Now, these dynamic injunctions have also taken new forms. My colleague Apurva will explain this in greater detail. Over to you, Apurva.
Thank you. Now,
Right,
post
I'm
the
going to jump in
judgment-
here, Purva. I'm going to jump in here. We have I think, a question for Abe, and then we'll kind of turn to you. I just think while we're talking on the subject, it'll be good to get that question out. So, Roshan, over to you for your question, sir. Thank you for your patience as well.
Thanks, Jay. So I have two questions. One, so the judgments that we are seeing are probably on the taking down the websites, right? So how is it? How is the Anton pillar or the dynamic injunction working on other aspects? It could be products or any other form of IP. One. The second is also slightly on the procedural aspect of the Anton pillar or the Ashok Kumar order. So understand that it's an ex parte order against infringers. So what happens next? So I get an ex parte temp injunction, or I'm not sure whether it's a permanent injunction. So as and when we identify the infringers, is it being included into the suit, or how does that work?
Okay. Thanks, Roshan, for your questions. Firstly, these orders are generally sought for. The dynamic injunctions are generally more concentrated on infringements which are happening on the digital space, and not necessarily on counterfeiting issues which happen. Secondly, as I told you, post this judgment of Justice Manmohan, the joint registrars have been given the right to entertain impleadment applications. So each time a new defendant is found, the plaintiff has been given the right to approach the joint registrar and make an application seeking impleadment of that new defendant in the suit. So that the new defendant becomes a part of the suit, and all reliefs which have been claimed against the defendants will also apply to this defendant.
Great, thank you. Abe, one follow-up question here. I mean, we're talking about the internet. A lot of this is not hosted in India per se. How does the international aspect work, and is it working well?
So yes, so in fact, Jacob, Apurva will be dealing with that aspect as she goes ahead with the presentation. But just to give an overview, yes, Indian courts have dealt with such a situation. I will not kind of explain too much and let Apurva do the explaining on that. And we'll be dealing with that aspect definitely in the presentation.
Great. In that case, ma'am, over to you.
All right. Thank you so much. So now that we've had the UTV judgment, dynamic injunctions have become quite a norm in terms of parties, plaintiffs who are looking to secure their right by virtue of a Ashok Kumar order or a John Doe order. And courts have also become very familiar with the underlying principles. So in terms of expediency, there is of course that benefit that you do get. Also, having the IP division in the Delhi and Madras High Court has, greatly benefited plaintiffs to this effect. Now, of course, there are other forms of dynamic injunction. While one form of dynamic injunction is permitting the plaintiff to identify other either URLs where infringing content is hosted or other parties who are conducting similar activities, but also other natures of relief, such as geo-blocking injunctions, which have been granted. Geo-blocking, primarily what it does is it restricts access to certain infringing content basis the geographical location. So, for example, the court could pass an order saying that certain infringing content would have to be blocked from India. For example, in this judgment, where is this Swami Ramdev versus Facebook and others, this suit was primarily in relation to a defamatory video and content in relation to a well-known guru in India, and where the defendants were intermediaries, which is Facebook, Google, YouTube, and other online intermediaries, which also included internet service providers and MATI and DOT. So the court directed that the defendant should take down the infringing URLs globally. Now, there are some issues which are associated with it for the reason that a lot of these servers may not be based in India. And the court also directed all the intermediaries to block access or disable viewership of this content within the territory of India. And the reasoning that the court provided was that as soon as certain content was uploaded from India and was made available globally, Indian courts have jurisdiction to remove such content, and then the cause of action would fall within the territorial jurisdiction of the courts. And but not just from, and it can be removed by, and it should therefore be removed by the defendants. Now, like Abhay was mentioning, there are varying views which are coming from the Delhi High Court on the threshold to be met by the right holder. While of course there are judgments like the Dabur judgment, which permits, and the Amul judgment, where the defendants in the nature of domain name registrars were directed to provide information in relation to the infringers, so to speak, unknown infringers. And in Dabur, there was an additional requirement, and even in Amul, there was an additional requirement that the domain name registrars do not grant or do not permit a third party to register a domain name which contains Dabur, whereby taking the policing action on their behalf, right? But now in the Snapdeal judgment, the Delhi High Court took a very different view on this. It said that that in order for it's not a feasible action to be taken by an intermediary. Of course, the right holder in this instance led arguments to say that it would be a great inconvenience to the right holder and that they would be required to approach the court during each instance of infringement, and that the domain name registrar should be directed to not grant any registrations in respect of domain names which contained the registered trademark of the plaintiff. However, the court was not in acceptance of this view, and they said that there is, of course, in fact, the specific paragraph that the court said was that the plaintiff has therefore necessarily to petition the court against each domain name that it finds to be infringing. This may be a long and cumbersome exercise. It cannot be helped. There is no shortcut to justice. So that's the view taken by the Delhi High Court on this. And therefore, for each domain name, there has to be a mechanism. Also, somewhere this view is sort of emanating from the EROS observation of the Bombay High Court to say that there has to be some threshold that has to be met. Like right at the beginning, Abhay spoke about what is the threshold a plaintiff needs to meet in order to avail itself of an injunction, which is prima facie case, balance of convenience, and irreparable harm. What a John Doe order of this nature or a dynamic injunction of this nature is doing is it's permitting the plaintiff to maybe not meet that threshold. And that's the sort of context in which there has been a sort of balancing which has happened in the Snapdeal judgment. Then in other forms of reliefs that have been granted by the courts, this is one judgment which is Neetu Singh versus Telegram. This related to the plaintiff who used to offer certain educational material, and her educational material was being circulated on Telegram, and different Telegram channels were getting created in which the material was getting circulated. And here Telegram was directed to submit the details of the infringing channels, including the details of their devices, IP addresses, servers, and mobile numbers of such users, etc., to the court. Telegram did object to it, and there were some defenses which were taken by the Telegram. I'll just quickly go over the nature of defenses that were taken and what was the view that the court took in respect of these. Firstly, was that the court took a view that the term plates, which is used in Section 58 of the Copyright Act, would include electronic devices such as smartphones, computers, servers, etc. Therefore, it did contemplate within the scope of the act and the legislation a mechanism whereby the court could direct the seizure of such infringing copies, which may be in electronic form or it may be held in electronic devices and computers. Telegram argued that the servers are in Singapore and therefore a direction of this nature cannot come from the Delhi High Court, to which the court did not agree, and they said that Singapore is a signatory to the Berne Convention, and applying that principle of reciprocity, they said that this order can be granted. Telegram also argued that it is an intermediary. However, the court was of the view that while it may be an intermediary and it's, there may be the question of its liability, something that is yet to be decided, it does not derogate from safe harbor. This will not derogate from the safe harbor provisions. In fact, it was aligned with the view of Telegram's claim role as an intermediary, that it's acting as a conduit. However, even if it's acting as a conduit, information that it is required to provide assistance. That's perhaps the balance of the benefit of the safe harbor, which is granted to an intermediary, so that they do, to the extent that they can assist with delivering justice, then they should. Separately, it was also argued that this disclosure could result in the violation of privacy, to which the court did not agree, saying that, if there is a need for a disclosure that is required, then as long as the disclosure is not disproportionate. So because there is a specific legislation which recognizes the rights of right holders, and there is and the court is duty bound to provide them certain remedies, which is in the nature of damages or rendition of accounts of profits, etc. Therefore, it would be in balance if the details of such infringers was disclosed by Telegram. Accordingly, Telegram did go ahead and disclose these details. Similarly, there is another judgment of 2024 where the plaintiff, which is the authorized service provider for processing PAN cards, filed a suit against several websites, alleging that the infringers were representing themselves to be agents of the service provider and issuing fake PAN cards. So the court took notice of the fact that this is a grave, public safety and issue, given that PAN cards are a sensitive document, and it directed all the domain name registrars to take down the domains websites, and also a dynamic injunction was granted here so that any further websites could also be identified, and they were also directed to provide the details of such players. Now, in conclusion, what if we were to look at dynamic injunction as a whole, or injunction from John Doe orders? Basically, the jurisprudence is entirely developed basis the actions of the court, of how they have sort of modulated and adapted different mechanisms to address the different methodologies that infringers have come up with over time. So, just to summarize, if a right holder has to approach the court to seek a dynamic injunction, they can do so in instances of online piracy, trademark or copyright infringement, cyber squatting, defamation and privacy violation, or similarly placed violations. What do they need to prove? They need to prove urgency and imminent harm, continuous or ongoing violation, and ineffectiveness of traditional injunctions, balance of equities, and a legal basis, of course, that is that they have the relevant rights to bring this motion. And of course, proportionality and scope is something that the courts bear in mind while granting these reliefs. And the nature of reliefs that a right holder can avail itself of include blocking or takedown orders, seizure or freezing orders, monitoring orders, which we have seen with some Delhi High Court orders, compliance and reporting requirements, because it's not there are some High Court, some judges have also taken the view that the plaintiff should periodically monitor the websites that have been blocked, to note that to the extent that the websites don't continue to violate or don't continue to infringe, then even that needs to be brought to the court's attention so that the internet service provider is no longer required to block those domain names. And modification and expansion of the injunction order subject to the dynamic nature of identifying additional defendants. So overall, this has been a helpful tool and right holders have availed themselves of this. Of course, we are seeing emerging trends in respect of how the courts are addressing the varying issues. And this is likely to be something that's, likely to see a lot of development periodically. Thank you so much. If you have any questions, we're happy to address them.
Incredible. Thank you both. Yes, we'll now turn to the Q&A portion. If you have any questions, feel free to type them in the chat or alternatively raise your hand and I can call on you. And then we'll stop. Perfect. We'll stop sharing screen. Let me see if there's any. George, over to you.
Good evening, colleagues, and good morning to those here in the U.S. Thank you so much for hosting today's panel. This is really fascinating, and these developments in India in the courts are something in the creative industry that we strongly welcome and encourage. I'm with the Recording Industry Association of America, and I handle international policy. And we've been working with colleagues at IMI. Blaise Fernandez in India for quite some time and really welcoming these developments. So thank you both to the chamber and to colleagues in India. Wanted to ask you a question about the legislative foundation for the judicial actions here. Is it considered fairly well on a solid foundation, these judicial orders, or have there ever been is there ever any concern in the direction that there needs more legislative foundation for these orders, or is that considered now by the courts to be sufficiently strong? And are there any efforts to pursue additional legislation in India to help support, firm, answer any questions that have been left unresolved through the courts? Thank you so much.
So thank you, George. I will try and answer your question, and Apurva, please chip in if I miss out on something. So the general view that courts have taken and what we have experienced is that the legislations that we already have are sufficient to deal with these infringements which are happening online. But of course, there are certain issues like which we obviously did not comment on today, like the metaverse or the issue of infringements happening through artificial intelligence, which require perhaps a longer session altogether, which are not sufficiently covered by legislation in India. But insofar as these dynamic injunctions are concerned and the infringements which are happening in the digital space are concerned, I think primarily the Copyright Act, the Trademarks Act sufficiently provide for protections to deal with such issues.
Yeah, and even major permits for ant-and-pillar orders. So it sort of ties in with that. And the Delhi High Court also periodically, has made rules to specifically govern specific issues, and which it's within its power to do so. So, and most of these are procedural in nature. So therefore, yeah, yes, it is supported by law to that extent. And I don't think I have not come across any order of a court where maybe a defendant has challenged the basis on which an injunction of this nature has been granted. Of course, the challenge may be on the plaintiff standing to bring a suit of such nature, but then not really on the mechanism that the court has adopted.
So in fact, interestingly, George, when we talk about dynamic injunctions and especially the case that Apurva and I dealt with of injunctions being passed, dynamic injunctions being passed against those Hydra-headed monsters, the court did consider a judgment of the Singapore court and followed that precedent. So courts are also considering international precedents. It's where the law is unclear. They are relying upon judgments of foreign courts as well.
That's thank you both. That's extremely helpful, and we greatly appreciate that information and look forward to hearing other questions. Thank you again.
Thank you.
Thank you.
Thanks, George. I'll open it up. We have time for a couple more questions. See if there's any in the chat.
Yeah,
Oh.
I'll jump in and ask a question. In another call that we had earlier this week, it had to do with source code testing that electronics manufacturers are going through. The issue of trade secrets came up, right? So India doesn't have a trade secrets law, is my understanding, but there was some talk that India maybe is thinking about doing something on trade secrets. Can you just talk a little bit about that aspect and if there's any scuttlebutt or any insight that you might have on India's response to perhaps a gap in IPR law around trade secrets?
So yes, so trade secrets are protected in India under the law of contract and equities under common law. There's no specific legislation. Courts look at various legislations like the Indian Penal Code or the IT Act or the Official Secrets Act when it concerns information which may affect the state, so to say, to protect trade secrets. There has been a debate whether we require a law on trade secrets, and I'm aware that one of the concerns which the US has expressed and which most US corporations have is that the infringement of trade secrets is not adequately protected in India, both in terms of the reliefs and the damages granted by courts. The mechanism by which trade secrets are protected and the reliefs. So there is, in fact, an emphasis and there is a talk about bringing in the legislation for protection of trade secrets. In fact, the Law Commission of India has recently made a recommendation to the government to come up with such a legislation. At least that is what the Law Commission chairman, who's a retired High Court judge, has expressed in the media. And I think it is very important for India to have a trade secret law because there are a lot of gaps while protecting trade secrets without a legislation. Because what happens is corporations don't know what to protect, what to let out. Employees don't know what to keep as a secret and what to let out. So there is a lot of fluidity in what is happening at all levels. So to curb that and to provide for, and perhaps the legislation can also look at a time-bound procedure where cases are decided. For commercial matters, we have the Commercial Courts Act, which prescribes certain time limits for doing acts, for filing pleadings, etc. So that mechanism can also be included in a trade secret legislation.
Perfect, thank you. And we have time for one last question, so I'll hand it over to John.
Hi, this is John here. Thanks, Abhay. Thanks, Apurva, for the presentation. I have one question. The Government of India, Ministry of Information and Broadcasting, notified certain officers for administrative takedown of infringing content in November last year.
Yes.
I wanted to understand the efficacy of administrative takedown vis-a-vis injunction orders, and what could be the potential risk, if any, that could be associated with the mechanism that the Government of India is currently sort of proposing.
So, look, these administrative officers are bound by what the court directs them to do. I don't think that they can exercise any discretion in whether to take down or not to take down content. It's actually a very effective way of getting content removed, infringing content removed, because it kind of helps in the entire mechanism. Once an order is issued by the court, the plaintiff has to go through one lesser step of getting the order enforced. And there is this a kind of a definitiveness that the order will be enforced since such officers have been appointed by the government on orders of the court, the guidelines which have been issued. In terms of drawbacks,
I'd say maybe one of the drawbacks perhaps is the fact that, because at least from an IP perspective, a lot of a finding of infringement or non-infringement is something that a court is primarily required to do. So I think that's where maybe the gap is that we are experiencing.
Thank you. Yeah, that's helpful.
Okay. Perfect. Thanks, everybody. This was really, really great. Thank you, Apurva. Thank you, JV. Thank you, Sam. In terms of what's coming down the pike, what's next, we'll be doing these IPR webinars quarterly. Like JV mentioned, we'll be broaching on different topics. So some will be focused more on AI or the metaverse. If there's anything you guys are interested and want to hear about, please let us know, and we'll make sure we'll start incorporating those. We'll also, as things come up, be doing rapid reaction webinars, and we'll also have some reading and articles on it as well that we'll be sharing. And if there's anybody else on your teams that you would like to be involved as well, please feel free to reach out to Jay, reach out to myself, and we'll make sure you guys are all included in all of our IPR related activities. So thank you again, everybody. I hope you have a wonderful rest of your evening or a wonderful rest of your day, depending on your time zone. All right. Bye.
Thank
everybody.
you.
Thank you.
Bye.
Thank you so much.
Thank you.
Thank you, everyone. Bye.